A divided North Carolina Supreme Court ruled Friday that domestic violence protection orders in the state must apply to same-sex dating cases, making the state the last in the nation to equally apply the law to LGBTQ people. Previously, Chapter 50B of the North Carolina Statutory Code only permitted married or divorced same-sex couples to seek a restraining order. Same-sex couples who were dating or living together were barred from the court's protection. In 2018, a woman in a same-sex dating relationship attempted to obtain a protection order against her partner. The Wake County District Court denied her request, twice, due to Chapter 50B. District Judge Worley found the woman's complaint credible, writing that the facts would have supported the entry of a domestic violence protective order, had the parties been of opposite genders. On Friday, the 4 Democratic judges of the state's Supreme Court upheld an appeals court ruling that the same-sex or opposite-sex nature of a dating relationship shall not be a factor in the decision to grant or deny a petitioner's protection order claim under the Act. The 3 Republican judges on the bench dissented, explaining they would have overturned the appellate court's opinion for technical reasons. The Fifth Circuit Court of Appeals blocked a Trump-appointed judge's order that prevented the federal government from considering the social cost of greenhouse gases when crafting rules and regulations. The social cost of carbon is an estimate of the economic damages of emitting 1 ton of carbon dioxide. Policymakers use the social cost of carbon to quantify the extra costs associated with carbon emissions that are not automatically reflected in market prices. The Obama administration had estimated the social cost of carbon at $43 a ton. Trump then lowered it to $3 to $5 a ton, and Biden raised it to $51 a ton. Republican states sued the Biden administration, arguing that Biden lacked the authority to raise the climate metric under the Constitution, which gives that power solely to Congress. Trump appointee James Kaine, of the Western District of Louisiana, agreed with the GOP and issued an injunction preventing the Biden administration from even considering the social cost of carbon. On Wednesday, a 3-judge panel, made up of 2 Obama judges and a G.W. Bush appointee, unanimously stayed Kaine's injunction. The court rejected the state's argument that the higher social cost of carbon metric could cause them injury. The government defendants are likely to succeed on the merits because the plaintiff states lack standing. The plaintiff states' claimed injury is increased regulatory burdens that may result from the consideration of the social cost of greenhouse gases. This injury, however, hardly meets the standards for constitutional standing because it is, at this point, merely hypothetical. Meanwhile, in Ohio, the Supreme Court has once again refused to accept the Republican-drawn redistricting maps, saying it is beyond a reasonable doubt that the main goal of the individuals who drafted the state legislative map was to favor the Republican Party and disfavor the Democratic Party. Chief Justice Maureen O'Connor, a Republican, was the deciding vote in a 4-3 decision. She writes, "The evidence shows that the map drawing process for all 3 districting plans we have reviewed has been controlled by the Republican Party. The evidence shows that the individuals who controlled the map drawing process exercised that control with the overriding intent to maintain as much of an advantage as possible for members of their political party. The majority ordered the Redistricting Commission to come up with a 4th plan for the state's legislative districts. The federal districts, for the U.S. House of Representatives, are also being reviewed by the court.